All right, final case set for argument this morning is State versus Joel Covender. It's case number 18CA011355. Both parties are represented by counsel, so each of you will have 15 minutes to present your arguments. Counsel for Appellant, you may reserve up to 5 minutes for rebuttal. If you'd like to do that, let me know and I'll try to keep track of and keep you appraised of the time.
Your Honor, I would like to do so.
Okay, just let me know how much time you need when you get up.
Okay.
I'm trying to remember if this case involves,
Minors.
does it involve minors?
Yes.
Okay, so let's use the initials. Yeah, if there's going to be any reference to victims or minors, we use initials as opposed to full names. And that's because we do record and post the arguments, so we want to respect that. We have read the briefs and are ready to proceed if you are, so how much time would you like to reserve?
5 minutes, Your Honor.
All right. Thank you.
May it please this honorable court. Your Honors, the issues that we are here for today are whether or not Covender satisfies the requirements of 2743.48A5, which is called the actual innocence prong of the wrongful imprisonment statute. The standard that is to be used for this prong of the statute is by preponderance of the evidence, whether or not Joel Covender is actually innocent of the crimes for which he was found guilty of in 1996. The second issue that we're here for today are whether or not Covender's convictions were vacated, dismissed, or reversed on appeal as required by 2743.48A4, subsection A4. And the third issue for which we're here before this honorable court are whether Covender filed case number dealing with victim JS, lowercase number 94CR045912 within the 6-year statute of limitations. I'll go with the first issue that I talked about first, whether or not Covender satisfies the actual innocence prong under 2743.48A5. Your Honors, we have heard several times, and this honorable court knows from reading the briefs, that on several occasions, both of the victims, alleged victims in this case, came before the court and testified that Mr. Covender did not, in fact, commit these crimes. As a matter of fact, when Mr. Covender was serving a sentence, an indefinite sentence, at his very first parole board hearing, both alleged victims came before the parole board with affidavits saying that these crimes did not happen. That being said, we attached motions for new trial. We attached affidavits to them from both alleged victims, and the lower court back in 2007 granted the motion for new trial for both of these alleged victims. Only one of those situation cases was appealed, that being AS, victim AS's court number case ending in 253, was appealed by the state of Ohio, which has led to this long delay in what's going on. But we're here today. Both cases, both children have sworn under sworn testimony, under cross-examination, also under public scrutiny, have stated that Mr. Covender did not, in fact, commit these crimes for which he was convicted in 1996. Also, the biological father of both children also witnessed and gave a sworn affidavit that he witnessed the children being coached by not only his mother, but also the mother of his mother-in-law, that being Nancy Coleman, as well as his mother, Debbie Sloan. And that was David Sloan's affidavit, which was attached as well to the brief. The appellee often cites that there was physical evidence which linked my client to these crimes. There just was no such physical evidence. There was some evidence that there had been some trauma done to these children, but the trial court, it was Judge Morality, indicated that because of the unsavory nature of the other family members who were around these children at the time back in the 1990s, there was no direct evidence, medical evidence, that Mr. Covender had committed any of these crimes, and that the testimonial evidence of both children were the only links to Mr. Covender committing these crimes. And of course, both of these children have now come forward on several occasions under oath and stated that these crimes did not occur, that Mr. Covender did not do this to them. As a matter of fact, if you read the plaintiff's brief in opposition to summary judgment, we went through many excerpts of the trial where victim AS stated that the only pressure that she was receiving was from her family, the people who were pressuring her not to come forward and say that Mr. Covender did not, in fact, commit these crimes. So we believe that Covender does satisfy the A5 subsection, the actual innocence by a preponderance of the evidence, not by evidence beyond a reasonable doubt, not by clear and convincing evidence of his actual innocence. One last thing, the appellee often states that recantation should be considered with the utmost suspicion, and that is absolutely true with regard to motions for new trial. This is a de novo review that you are doing here. It's not a motion for a new trial, which should be looked at with the utmost suspicion. We've gone back to trial. AS has testified on behalf of Mr. Covender. He was found not guilty in the lower court. We're here to be adjudicated a wrongfully imprisoned person. The second issue, the appellee states that the Court of Appeals is required to vacate, dismiss, or reverse on appeal in order to satisfy 2743.48A4. That's just not the case. There are many cases where there's new DNA evidence or something to that effect where a motion for new trial can be filed and it's granted based on the new evidence, i.e. DNA. And there's no Court of Appeals involvement. The state acknowledges the fact that this new DNA testing has proven that the perpetrator that's been convicted, previously convicted, did not commit these crimes. They don't go to the Court of Appeals, you immediately go to the Court of Claims to seek compensation for being a wrongfully imprisoned person. I think it's incorrect to assume that it has to be the Court of Appeals, which they usually don't vacate cases, they usually don't dismiss cases, they reverse and remand, it's my understanding at least, for further proceedings by the lower court. Finally, I don't know how I'm doing on time.
You've got a total of 9 minutes and 20 seconds left, so
Do
you
it
have plenty of time left. Yeah.
With the reservation of the 5?
Within that 5, so.
Okay.
9 minutes, 18 seconds total.
Total, okay,
Yeah.
thank you. Thank you very much, Your Honor. The third issue, Mr. Covender filed his claim within the 6-year statute of limitation. Remember that the first time that Mr. Covender filed for a motion for new trial was in 2007. The court granted the motion for new trial on July 18th of 2007. Granting the motion for a new trial is not where the statute of limitations should run. It was when the state of Ohio came and dismissed the case. Because remember, just because the court grants a motion for new trial, there could be another trial. We could go before the pretrial process and then have another jury trial or bench trial. So it would not be proper for that to be the time to consider when the statute of limitations will start to run. It was on August 15th of 2007 that the state of Ohio came and voluntarily dismissed this matter as to victim JS. And at that point in time, on April 15, 2007, that's when the statute began to run. Of course, and the civil case was filed on August 15th of 2013, exactly 6 years to the day within the statute of limitations. So we believe that on all 3 of these issues, Mr. Covender does prevail. We would ask this honorable court to reverse the decision made by the lower court to grant summary judgment for Mr. Covender and deny summary judgment for the state of Ohio. Thank you.
What does the statute say concerning your argument that it must be vacated, that does not need to be vacated, dismissed, or reversed by an appellate court? Does it specifically state that it must be an act by the appellate court?
It does not specifically state, in my reasoning, my reading of the plain language, it does not state that it has to be a court of appeal. It can be vacated, that's one way, dismissed is another way, or reversed on appeal.
By any?
By any court, correct, because like I stated, a case could be vacated by the trial court and dismissed by the prosecutor at the trial court level and never appealed. And therefore, a person who has a right to recover under this statute would not be able to if taking it in the light of the appellees, the way the appellee sees it.
Thank you.
Questions? Okay. Thank you.
All right, thank you. You'll have a full 5 minutes for your rebuttal.
Thank you.
And counsel, you have 15 minutes.
Thank you, Your Honor. Thomas Madden here on behalf of the state of Ohio. The wrongful imprisonment statute was only intended to compensate those who are truly innocent, not those who avoided criminal liability. I mean, the history of this case shows that there was definitely the children victims in this case when their recantations were highly under suspect, that the trial, that when they motions for new trials were denied and appealed, they were sent back, affirmed. So there's never been an appellate court who vacated, dismissed, and if you look at the statute in particular, 2743-48A4, the individual's conviction was vacated, dismissed, or reversed on appeal. And that's not, that, all three of those qualifiers, all three of those words revert to on appeal.
There's commas after vacated and dismissed.
Pardon?
Just grammatically, it would seem to me that vacated comma, dismissed comma, or reversed on appeal, those would be three separate things. Is that not how your interpretation of it is?
And no, and it's not just me. My interpretation is, it goes along with, if you look at the legal text by Scalia and Brian Garner, the series qualifier canon instructs that when a straightforward parallel construction, which involves all nouns and verbs in a series, a modifier normally applies to the entire series. So, on appeal applies to all three of those. And so that's the state's position on that. And this statute has been litigated and litigated and litigated before the Ohio Supreme Court. And the Ohio Supreme Court, in particular, this statute has rejected every attempt to interpret this statute different than what it says. And those, the two main cases that do that are CK and Manzaret. And, you know, and both CK in particular and Manzaret also, you know, the argument was consistently made, well, if you interpret it this way, then the statute's ineffective. And the Ohio Supreme Court said maybe so, but you have to interpret the statute in the manner it was intended. And so it's the state's position that all three of those words refer to on appeal. And in this case, none of these things happened on appeal. He was sent back, you know, for the judge granted a new trial, and then they were acquitted. Now, acquitted does not reach the level of actual innocence either. That's the Doss case. And the Ohio Supreme Court said, listen, just because you were acquitted, you avoided criminal responsibility, doesn't mean you took that extra step of showing that you were actual innocent. And in this case, you had recantations that are highly suspect under the law, and then you had physical findings by Nurse Thompson on a medical evaluation that supported the children's original testimony.
Was there DNA?
No, there was no DNA in this case, to my knowledge.
Wouldn't any recantation be suspect? Aren't all recantations suspect?
All recantations are suspect, and sometimes you just have a recantation. In this case, you have a recantation, but you also had evidence that supported the original trial testimony. So in this case, you had the victim children testifying that their stepfather had abused them, and then you had a nurse come in and say their testimony is corroborated
that they were abused.
That they were abused, and that's different. So you have a situation where you have to be inherent that recantations are inherently suspect as a matter of law, and also you have corroborating testimony that's never been refuted. And so the Judge
Maraldi said, due to the nature of this family.
Yeah, he said due to the nature of the family, I'm not going to convict, but therefore you're acquitted. But that, according to Doss, that's not the same as saying, but I hereby find that you're actually innocent. And that's what the plaintiff in this case can't overcome, is that there are factual findings that supported the testimony, the prior testimony of the children, and he can't overcome that. And when summary judgment was granted below, that was fairly obvious from the record.
So you're saying that Doss requires a court's entry in these situations to actually declare an individual is actually innocent as opposed to just making a finding of guilt or not guilty.
That's right. And that's why whenever you win or lose below on an actual innocence claim, the standard is manifest weight. So it would even be a different standard. So that's why the trial court would have to conduct a trial and find actual innocence. But in this case, the trial judge didn't need to get that far because the recantations were inherently suspect, and you had factual findings that supported the original testimony, which plaintiff can't overcome. And it's true that Judge Moraldi said, well, there's a bunch of people in the house and therefore, who knows, but that's not showing that you're actually innocent. That's not overcoming that. And in fact, the Ohio Supreme Court, and I think it's the Doss case, just says you almost have to prove a negative. That's why we're not going to open the coffers to state resources unless you affirmatively show that you're innocent. And in this case, he hasn't done.
Well, how could he have in this case?
Well, it's difficult. It's inherently difficult. DNA evidence, maybe finding an expert who would have testified that, when Nurse Thompson testified that those medical findings supported the children's original testimony, well, that was junk science, and then we'd have a trial on that. But he's never gone that extra step. All he's done is saying, okay, I am now rekindled my relationship with my stepchildren once they're adults. They're saying that this sexual abuse never happened. That's all he's relying upon. He's not refuting or attempting to refute the corroborating evidence. Is probably why the jury convicted in the first place. With that, Your Honors, unless the court has further questions, I will rely on my brief.
Okay, no other questions? So,
Thank you.
Thank you for your argument.
I will note this, the Ohio General Assembly recently changed the statute. There's a big question about whether or not it's retroactive.
Not in this case, so. The argument's not raised here.
The argument's not raised here, but they just did it. It only took effect on March 22nd.
Was that part of SB 201?
I think it changed A4 and parts of A5, but not the actual innocence prong of A5, which I'm primarily relying on.
All right, thank you. Counsel, you have 5 minutes for your rebuttal then.
Thank you, Your Honor. I forgot to introduce myself, Attorney Scott Ramsey.
Thank you.
Your Honor, there's not one case that has required that the A4 prong of this statute required the Court of Appeals to vacate or dismiss the case. There's not one case law, there's not one precedent that requires that. And once again, I point to the example that I gave when there's DNA evidence and a new trial has been, a motion for new trial has been granted, and the state of Ohio itself dismisses the case because the DNA evidence has exonerated the person who's been convicted. There's no Court of Appeals involvement, and we've seen case after case where that person can go to the Court of Claims for a wrongful imprisonment statute. Now, I do agree with counsel that actual innocence is required, and it's not just being found not guilty by the lower court. And we're not offering that. We're stating that Mr. Covender is in fact innocent, that the two alleged victims came before the parole board and have repeatedly tried to help him because they know that they lied back when they were 5 and 6 and 7 and 8 years old. Because this lasted from 1993 to the trial date of 1996. If you please look at the transcript that I have offered in my brief in opposition, where Amber Sloan asked the question, that's why you're doing it, i.e. testifying. She answers, I'm doing it because an innocent man deserves to be innocent. I'm sorry, I mentioned her name. J.S. testified on June 14th of 2007. Okay, and specifically, what were the allegations you made? That he touched me in bad places, put his hands down my pants, put his finger in my rectum. And that was in 1994. Question, answer, yes, that was a long time ago. How old were you when you made these allegations? Answer had to be 5, almost 6. Okay, and eventually in 1996, you gave testimony to that effect in court. Is that correct? He says, yes, sir. Now the question, I'm gonna ask you a direct question, were those allegations true? Answer, no, sir. Did it ever happen at all? No, sir. Okay, were you lying? Yes, sir. And repeatedly, time after time, these two alleged victims have come forward trying to right a wrong that was made back in the 1990s. That these things did not happen, that Joel Covender did not commit these crimes. We're not relying on the acquittals. We're stating it actually did not happen. The last thing I want to point out, before I'm running out of time, is the court asked a question. Judge Moraldi, the lower court, indicated in his order back in 2007, furthermore, given the particular nature of the allegations of digital penetration, the medical and forensic evidence and testimony was consistent with both parties' contentions, and therefore did not corroborate the allegations. He further stated that other family members with unsavory backgrounds as former victims and perpetrators of sex abuse were around these children all the time. And because of that, there's no link to Joel Covender committing these crimes other than the testimony of these two children. They've repeatedly done all they could. They've done all they could do to come forward and say this man did not commit these crimes. So we'd ask on that basis that this honorable court reverse the decision of the lower court.
Do you think he had to go farther and conclude with a sentence that he finds that Mr. Covender is innocent?
Pardon me, I'm sorry.
Do you think the trial court had to go further to find that the defendant in this case was innocent of the charges?
The trial court in the criminal trial, no, he would just find his standard was, did the state prove by evidence beyond a reasonable doubt prove that Mr. Covender committed these crimes? We asked the civil court by preponderance of the evidence to find that Mr. Covender satisfied the A5 prong of actual innocence in this matter. Preponderance of the evidence and not by evidence beyond a reasonable doubt. And I think the court asked a great question. How could he have done this? How could he prove himself innocent? And the only ones who can testify about that are the children.
All right, thank you both for the arguments in this case. We will take the matter under advisement, issue a decision in due course. Of course, you'll receive copies from the clerk on the day the decision is released. You can also check the Supreme Court of Ohio's website where the decisions are posted. We're going to be adjourned.